Patton.
He's not listening to his attorney. That's what the problem is.
The statute.
The 25-year minimum, which probably caused a dispute, which why he wants you removed, because a new attorney is going to come in and tell him it's not that. You've got to be kidding me.
Sir. Michael Gaddy, Assistant Public Defender for Mr. Patton, Your Honor.
Your name, sir?
Andre Patton.
What are we doing?
What did you state your name? Okay. Your Honor, I have
hours ago
discussed this matter with the prosecutor and with Mr. Patton. We'd like to set this matter for a preliminary.
This is next.
Your Honor, the people have offered not to habitualize this matter. What's commonly referred to as the super habitual. If he were to waive, see.
Discovery is complete.
To the best of my knowledge, Judge.
Do I have their witnesses available the 14th? Preliminary examination will be set July 14, 2026 at
9 a.m.
That just messed you up, didn't it? At 9 a.m. before Judge Garwood.
Just see a moment. Can I speak?
Attention, sir.
At this moment, I would like to get something on the record. I would like to remove Mr. Gaddy as my legal representation.
Okay, why?
Information I could have used earlier. Yeah, it's
Why do you want to do that?
I don't feel he has my best interest at heart.
Seriously? You're saying Mr. Gaddy has a client that he doesn't have their best interest at heart?
Mr. Gaddy.
For that, Mr. Gaddy, how long have you been practicing?
a little bit, Judge.
A little bit, like 25 plus years?
Yes, Judge.
And you're going to tell, and he's been practicing before me for that long, and I've never seen a point in time ever that he didn't have his client's best interest at heart until today.
Mr. Gaddy has been very argumentative with me in certain instances.
Maybe he's told you what you need to hear, but you're not listening?
No, he has done that.
Okay, that's his job.
I understand that, sir.
So are you going to hire your own attorney?
No, sir.
Well, you got the PD's office. That's it.
Sir.
And the PD then has assigned Mr. Gaddy to represent the case. So if you want to do something different, I'm going to undo this setting of preliminary examination, and I'll just adjourn it out for you to decide what you want to do.
I would like to move forward to prelim.
You would like to move, and you understand that Mr. Gaddy will be your attorney maybe on that prelim.
Okay.
Well, okay, what?
Move forward. I have to move forward to preliminary hearing.
So you're withdrawing your request to have Mr. Gaddy removed?
I am, sir.
Probably a smart move.
At this point, Judge Simpson is testing whether Patton has identified a genuine representation problem or is simply reacting to unwelcome legal advice. A defendant represented by an appointed public defender generally cannot obtain a different lawyer merely because counsel is argumentative, blunt, or recommends a strategy the client dislikes. The court looks for something more serious, such as an actual conflict, a complete communication breakdown, or deficient representation. Patton offers no concrete example of Gaddy acting against his interests, while the judge places counsel's 25-plus years of experience and professional history on the record. That does not automatically prove the relationship is healthy, but it explains why the accusation receives immediate scrutiny. Notice the strategic question Simpson asks: will Patton hire private counsel? When the answer is no, removing Gaddy could disrupt the scheduled preliminary examination without solving the underlying disagreement. Patton then withdraws his request and chooses to proceed. Was that a considered decision, or did he retreat once he realized substitution was not automatic? The unresolved issue is what advice triggered this conflict, and whether Patton fully understands the consequence of rejecting it.
Yes.
I apologize, Your Honor. I was going to say that the offer was not going to be kept open. For example, it was kept open until this hearing, and at this point, it will not be kept open.
It will not be kept open until he can get the habitual.
25. Right.
You understand that? And you still want to go forward with prelim?
Your Honor, I don't know if Mr. Patton...
He's not listening to his attorney. That's what the problem is.
Your Honor, I don't know if Mr. Patton would consider, in the court would consider adjourning this 1 week, and the prosecutor consider keeping that open so that he can... I have advised him of this. I've explained the
the
statute.
the 25-year minimum, which probably caused a dispute, which why he wants you removed, because a new attorney is going to come in and tell him it's not that. You've got to be kidding me.
I don't know if Mr. Patton, in your honor, would consider it appropriate maybe to adjourn this 1 week so I can make sure that he is. I'm very sure he's fully aware. I just want to make sure that given the events of today, that he is completely aware and there's absolutely no confusion or question about it. But that would be up to him, Ms. Zenda, in your honor.
I would have no objection.
What do you want to do?
Want a better understanding of what's going on.
So you want me to adjourn it so you can talk to Mr. Gaddy and listen to what he has to say? You may not like what comes out of his mouth, but you...
Not that, sir.
Pardon?
Not that. It's not that I don't like what's going on. It's not that I don't like what he's saying.
What do you want me to do? You want to go ahead with your preliminary examination or you want an adjournment? Those are your choices.
I'm going to waive my prelim. I don't want to do that.
Nobody's asking you to waive your prelim. You want your prelim or you want an adjournment at which time decide after that adjournment that you want a prelim, it'll be set for a prelim. Those are your choices. Pick one.
Understanding, sir, what they were telling me was if I adjourn my preliminary, it will move the habitual. That's what was explained to me. Is that not correct?
No, Your Honor. I've explained that the people have offered, and again, I've explained that the people have offered not to habitualize this matter and such in the way stated with the mandatory 25 should there be a waiver, and that the people would withdraw that offer once an exam is set. I don't think we had adjourned this last week or last time for this eventuality, and we did discuss the matter. So, to the extent that there may be some confusion, I think perhaps adjourning this a week would.
Is that what you want to do, sir?
We can adjourn it, sir.
Where is it? Just mark it. You want 1 week or two, Mr. Gaddy, for him to understand what's going on?
Your Honor, I can. I believe 1 week will be ample.
During July 9th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Yeah, just so everyone's aware, Ms. Zenda will leave that offer open until next week.
Because she's a lot nicer than I would be.
Now, the real source of the conflict is clear. The prosecution has offered not to seek the enhanced habitual offender treatment carrying the stated mandatory 25-year minimum, but that offer is tied to waiving the preliminary examination and can be withdrawn once an examination is set. A preliminary examination is valuable because it requires the prosecution to present enough evidence to move the case forward and gives the defense an early look at the case. But exercising that right may come with a steep plea negotiation cost here. That is why Gaddy requests 1 week. He is protecting Patton from making a high-consequence choice while confused and protecting the record from a later claim that the decision was uninformed. Judge Simpson narrows the options instead of debating every misunderstanding in open court. He adjourns to July 9th, continues bond, and confirms that the prosecutor will preserve the offer. Do you think 1 week is enough to understand a decision carrying this level of exposure? The judge's sarcasm toward counsel is sharp, but the operative ruling is cautious. No waiver is forced, no preliminary examination is lost, and the negotiated option remains temporarily available.
Gaddy, apparently you don't know what you're talking about.
Good morning, Your Honor. And you're PH 7447 on behalf of Defendant Sarah McCormick.
We're trying to.
Right, yeah.
Good morning, Your
thank
Honor.
you.
Sarah McCormick.
Thank you. All right, what are we doing?
Judge, the prosecutor has offered me a deal to drop this down to a misdemeanor substance use. I have recommended this to my client. I've been trying to get in contact with her, but I've been having a hard time at Huron Valley. I reached out to 3 different people, her sister, her boyfriend, and a friend to get her the message. I don't know if she's received the message and she's ready to accept the plea here. If you don't mind me asking my client, because we're ready to move forward. Sarah, have you received my messages? I've been trying to contact you.
Communications.
I have. This is completely unorthodox. I just spoke with Mr. I had a 6-hour parole board meeting regarding the suspension of my release pending the outcome of this case. I didn't know yet until yesterday what the matter was.
Ma'am, I'm going to stop you because this is not something everybody should be hearing. Okay. I hear you. I get it.
Sorry.
But no, it's not your fault. Really, it's not yours. Counsel, you're going to need to get in touch with your client, have that private conversation, then make a decision as to what they want to do without everybody else like you're being involved. So
I'm ready to move forward, though.
Pardon?
I'm ready to enter a plea. I'm trying to agree to this.
We're pleading guilty to the amended charge.
I don't have the paperwork.
Okay.
So I can't do anything, or I'm not going to do anything.
Thank you, Judge. I'll have the paperwork complete with the prosecutor. We'll get it over to you, and then we'll move forward to the next hearing.
When's that going to be? I was supposed to leave last week, and my husband's terminally. He's on the kidney registration list. Like, I'm his caretaker. I was supposed to leave 11 months ago. This is holding me up. The parole board said, PR bond or not. Mr. Sitto, I'm completely blown away. But I have a right to move forward with this. My civil liberty is being deprived.
Sarah, stop.
Ma'am, the quickest I can get you in, because we have to do a video writ, would be the 16th. I will set it as quick as possible. We'll get it. They'll get the paperwork to me, and I'll be more than happy to take your plea.
Thank you, sir. Thank you so much.
You're welcome. July 16th, 2026, 9 a.m.
Thank you, Judge.
Thank you. Thank you.
Thank you.
These hearings share one lesson. Speed matters only after the defendant understands the legal choice and the court has a reliable record. In Patton's matter, Judge Simpson did not remove appointed counsel or force a preliminary examination. He granted a 1-week adjournment to July 9th, continued bond, and confirmed that the prosecutor would keep the non-enhancement offer open until then. That preserved Patton's options while highlighting the danger of rejecting experienced advice simply because it is unpleasant. The stated risk, a mandatory 25-year minimum if the more severe habitual treatment is pursued, made clarification essential. In McCormick's matter, no plea was accepted. The judge stopped sensitive discussion in open court, required counsel to complete the paperwork, and scheduled the earliest stated video plea date, July 16th. Her family and release concerns explain the urgency, but they do not prove the terms of a plea or permit the court to skip formal safeguards. Do you think the judge struck the right balance between procedure and personal hardship? The broader takeaway is that disagreement with counsel, lack of understanding, and a genuine breakdown in representation are not legally interchangeable. Judges must also avoid creating a rushed record that can later be challenged as confused or involuntary. Here, delay was not punishment. It protected both defendants from irreversible decisions made without clarity. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.